good
Pandya.
morning. A very good morning to our esteemed speaker for the session, Prof.Dr. Barbara Pozzo, Professor of Law, University of Insubria at Como, Italy, Dr. Mayuri Pandya, Director of Faculty of Law, GLS University, and all the participants and viewers who have joined us for the first plenary session of the virtual international conference on changing dimensions of climate change in global north by Professor Dr. Barbara Pozzo. I request our director, ma'am, Dr. Mayuri Pandya, who is an exceptional academician, a member of the Expert Appraisal Committee, Ministry of Environment, Forest and Climate Change, Government of India, a member of the State Expert Appraisal Committee, and the Environment Appellate Authority of the Department of Environment and Forest, Government of Gujarat, to give the welcome address. Ma'am, over to you.
Thank you, Forum. I welcome Dr. Pozzo to this plenary session one of the International Conference on Climate Change Governance and Law. Dr. Pozzo is the Dean and the Professor at the University of Insubria at Como, Italy. Ma'am, I heartily welcome you to this plenary session one and your expertise in the subject of the comparative international law. And we all are eagerly awaiting to hear more from you, and specifically in terms of the comparative law, in terms of the climate action and the climate change. I welcome you to this plenary session one. Over to Forum.
Thank you, ma'am, for your warm welcome. Now I welcome Dr. Payal Mehta, Assistant Professor, Faculty of Law, GLS University, for her opening remarks on the plenary session 1, that is, Changing Dimensions of Climate Change in Global North. Over to you, ma'am.
Thank you, Forum ma'am. As Mayuri ma'am rightly said, this is the era where environment is the prime concern, not for any particular country, but for overall, for each and everyone. Everyone has to give and do their bit. I think GLS University has done its bit by arranging a virtual conference which is completely focusing on changing dimensions of climate change in global north by uh, that you will be addressing, Dr. Barbara Pozzo. This is the plenary session one that you would be addressing with this subject. As GLS University has taken immense pleasure with this second international conference on climate change and governance and law, and we are also having the Harita Mukh that was unveiled in inaugural session, that is the compendium of all the abstracts, and it is having 7 various themes including law, policy and governance of climate change, corporate climate infusement, human rights and climate change cluster, and papers received covered various contemporary issues and challenges pertaining to climate change, enforcement of relevant laws, and to mitigate the environmental pollution. And participants have been from more than 15 countries and other than India, and like that from various countries like South Africa, Southeast Asia, Middle East, Bangladesh, Philippines, Afghanistan, Egypt, Fiji, Indonesia, Australia, and Zimbabwe. And they are focusing on various aspects of climate change and its adaptation and mitigation while identifying the roles of the stakeholders. So this is all about it, ma'am, and we would like to hear from you and your views. Over to you, uh, Dr. Foram Pandya.
Thank you, ma'am. Before we begin with the session, I take this opportunity to formally introduce our guest speaker, Professor Dr. Barbara Pozzo. Ma'am is a professor of law and dean at the Faculty of Law of the University of Insubria at Como in Italy, where she teaches comparative legal systems, comparative law and language, and legal transitions since the year of 2001. Ma'am is the director of the summer school program in comparative environmental law in association with the UC Davis Law School, which is approved by the American Bar Association. Since 2002, Professor Pozzo is the director of the PhD program in comparative law at the University of Milan, where she also serves as the director of the master's program in environment, energy, and climate change law. Ma'am is also the director of the postgraduate course in fashion law that has been held at the University of Insubria and at the University of Milan. Ma'am received her JD from the University of Milan and her PhD degree in comparative law from the University of Florence. Ma'am, I request you to please begin with your address. Our participants and viewers are eagerly waiting for the same.
Thank you very much for these kind words. I am very pleased and honored to be here with you today. For me, it's such a pleasure to collaborate with a prestigious Indian university like yours. For me, it's like going back to the roots, as I was saying before to our guests. I was born in India many years ago, and it's always a pleasure to collaborate with an Indian university so prestigious like yours. So, as many of you have already told, I am a comparative lawyer, so I will address the issue of climate change litigation from a comparative law perspective. This is the topic of my research in the last years, and I also would like to say that in Italy there is a national PhD program to which I have joined recently that is focusing on these issues. The national PhD program on climate change and sustainability is all in English, and Indian candidates are very welcome. So please, if somebody is interested, also of your students, please contact me, because I think it can be a real opportunity to collaborate also in the future together. So I will address, as my presentation already tells you, the issue of climate change litigation in a comparative law perspective, but knowing that Professor Gita Gill is going to speak after me, my dear friend and colleague, Professor Gita Gill, I will especially focus on what is called the global north. So please, next. So I will first introduce the subject of climate change litigation in a comparative law perspective, and then I will focus on a concept that comparative lawyers use to analyze various issues, that is the concept of legal transplants, because I think this is a very important key concept in this kind of research. Then I will spend few words on global south and global north, explaining then the development of climate change litigation in the US and in Europe in a comparative law perspective, explaining then how legal transplants can be an interesting issue in investigating on climate change litigation nowadays, and then I will try to draw some conclusions. Please, next. So, as many of you know, it is, now something that is very clear to everybody. Climate change litigation is spreading all over the world, and for us comparative lawyers has become a very interesting topic of research. It is in fact not by chance that the International Academy of Comparative Law, in the International Conference of 2018 that was held in Fukuoka in Japan, has devoted an entire panel on the issue of comparative climate change litigation. The proceedings of this conference have been now published last year, and I think it's very interesting to see that comparative lawyers, the more and more are interested in this topic of research. Please, next. And there are two important tools in drawing our research that I would like to point out, because this can be of big interest for everybody, but especially for students and PhD students. And I would like to point out that the Sabin Center for Climate Change Law at Columbia University in New York, together with UN, have a special website on this matter that you can find at the website pointed out in the slide, but also that the Grantham Research Institute always publish practically every year snapshots on the global trends in climate litigation. Please, next. So then I would like to come to this concept of legal transplants, because this is a key concept in comparative law research that I would like to point out and spend some words about it. So legal transplants is in fact a pivotal concept in comparative law analysis. And by legal transplant, we identify the phenomenon with which we look at process of imitations from one legal system to another of norms, institutions, but also legal concepts. And this way of circulating, of diffusion of ideas, institutions, or norms is very interesting from a comparative law perspective, because we would like to understand the reasons why these transplants happen, but also the impact and effectiveness of these legal transplants, how these transplants are received, interpreted, and implemented, because it's, how can I explain? It's not a given that something that works in France can also work in Brazil, or something that works in Germany works also in Italy. It depends on many different variables, on the legal background, on the legal mentality that each country has developed. So it is important not only to understand why these legal transplants happen, but also if once they have happened, they are really implemented and become effective. And for sure, the other point of view is to see who are the actors behind them, and which are the forces that promote them. Please, next. Okay, no, to the right one. Thank you. Okay. So in the field of climate change litigation, these legal transplants happen very frequently and with different dynamics. So from a comparative law point of view, it is very interesting to analyze which are the drivers behind them, the final results that they are able to achieve. And this kind of analysis for us, it is much more important than the simple or mere juxtaposition of national reports that sometimes are made or are published in literature. Please, next. No, go back, please, to the map. Okay, so we have this map that is a very typical map that we find when we speak about global south and global north. Okay, this is, on my opinion, on the one side, a very important concept to bear in mind. On the other side, I think that it can become a oversimplification of what we are investigating on. Please, next. So, a global climate change litigation originates in the global north. It originates in the United States. We will see how Europe has taken over the lead. But the important thing here, in my opinion, is that, as I was saying before, although the divide global south, global north may help us in understanding the different perspectives and also the different dynamics on climate change litigation, I think it is an insufficient tool to describe and explain all the different phenomena at play. Please, next. So, it is clear that climate change litigation finds its origin in the United States. And it finds its origin in the United States for several reasons, but I think that the main reason is that climate change litigation in the US is representing an answer to the absence of a federal regulation. So this wave of litigation was aimed not only and not so much to get damages arising out of climate change, but much more to get regulation through litigation. Please, next. So this reaction to the absence of a regulation at federal or at state level, it is very important to understand, because in my opinion, the use of litigation to address the consequences of climate change might be viewed as a part of the regulation through litigation movement. And I would like here to quote work by Viscusi, Regulation Through Litigation, that goes back to 2002, that explains very well the kind of also mentality that lies behind this movement, which is not only typical in the field of climate change, but was also employed in the field of tobacco litigation, just to quote another important example. Please, next. Okay, so it's impossible for me to go into details of what happened in the United States, but for sure we can see that since the end of last century, this wave of climate change litigation is developing in the United States. It is only much more recently that climate change litigation has developed also in Europe, where it has taken a very different path. In fact, we cannot say that in Europe, climate change litigation is the reaction to the inactivity of the legislature. On the contrary, because since the late 80s, the European Union has always wanted to play an increasingly active role in pursuing a coherent environmental and energy policy strictly connected with climate change regulation, both at national and international level. Please, next. So, why is then climate change litigation spreading out in the EU as well? Well, there are many reasons. First, because many environmental association want to challenge the effectiveness of our legislative framework, because we have certainly a much more detailed legislative framework in comparison to the American one, but not always it has proved to be effective. And in fact, the citizens are tired of very challenging promises that at the end seem not to reach the goal, so are not effective. And on the other side, we also have to remember that there are very important NGOs and environmental associations that are favoring this process. Please, next. So, on the one side, climate change litigation in the EU has been certainly inspired by the important evolution of cases in the US, but on the other side has a very different background and has elaborated its own original tools. And the fact that the US and the EU belong both to the global north is insufficient to describe what is happening in reality. Please, next. So, what I want to point out is that the real important wave of climate change litigation has in Europe has been developing since 2015. Please, next. In this year, we have had, and Justice Preston has already pointed out the importance of this case in his very complete and detailed presentation. In this year, we had the Urgenda case. The Urgenda case is a very important case because it is the first winning case that we had in Europe. The case that gave very much hope to all the environmental associations to promote this kind of cases. So on the one side, it was based on tort law, and on the other side, it was based on a very broad article of the Dutch Constitution. So as far as the tort law was concerned, we have to remember that in the Dutch Civil Code, there is a very general provision that we find in many other civil codes of Europe, and that finds its origin in the French Civil Code back 1804, which more or less says, I must say, in many countries practically with the same wording, in Italy as well, a person who commits a tort towards another which can be imputed to him must repair the damage which the other person suffers as a consequence thereof. So this is a very general tort. I would like to say that civil law does not have this tort system that has specific torts, each one related to a specific hypothesis, but has generally this very general perspective on tort law. On the other side, we have Article 21 of the Dutch Constitution that, as many other European constitutions, gives a right to a clean environment. In the particular case, Article 21 of the Dutch Constitution states that it shall be the concern of the authorities to keep the country habitable and to protect and improve the environment. From this provision, that is framed as a duty of the state, a duty of the authorities to keep the country habitable and to protect and to improve the environment. A specific doctrinal construction has elaborated a fundamental right to the environment for every citizen. Please, next. So, I don't want to go too much into details because Justice Preston has already spoken about this case. But with this Urgenda case, the Foundation Urgenda sought and obtained a ruling that the Dutch government had violated its duty of care towards its own citizens, which entailed an obligation to take adequate action to cut greenhouse gas emissions. Please, next. So, under the due care standard of Dutch tort law, the court tested whether the state fulfilled its duty to care towards its citizen, And on the other side, I also would like to stress how the Urgenda Foundation, through the various steps of judgment, first instance, second instance, and third instance, brought together all possible legal sources that could be considered relevant when determining what could be expected from a national government in the combat against climate change. Please, next. So on the one side, we have seen that the Urgenda Foundation was basing the suit on tort law, on the Dutch constitution, but it was also referring to international sources like the European Convention on Human Rights, in particular Article 2 and Article 8. The Article 2 establishes a positive obligation on states to take appropriate steps to safeguard the lives of those within their jurisdiction. And Article 8 requires states to adopt positive measures designed to ensure that environmental degradation does not seriously affect private and family life or the home. This is the result of a long-standing jurisprudence arising out of Article 8 in the Court of Strasbourg. Please, next. So on the other side, Urgenda Foundation was also referring to important articles of the United Framework Convention on Climate Change, especially Article 3.1 that requires parties to the convention to protect the climate system for present and future generation, and Article 3.3, which in connection with Article 3, in connection with Article 191.2 of the Treaty on the Functioning of the European Union, introduces the precautionary principle, which indicates that states should not postpone taking cost-effective measures to protect the environment until full scientific certainty has been achieved. So the other doctrine that was quoted, and which in my opinion is interesting to mention, is this doctrine of hazardous negligence that was developed by the Dutch Supreme Court and also in academic literature, which requires the state to exercise due care with its climate policy. Please, next. Okay. So on the other side, the Dutch court did not accept all the objections put forward by the Dutch state because the Dutch state was of course, defending its way of operating, and was particularly introducing the argument that the possible acceptance of the action would have entailed an interference in the discretion of the legislative and executive powers. And also that the further reduction in Dutch emissions required by the actors should have been considered irrelevant in view of the fact that the Dutch contribution to global emissions could be considered as minimal. So without further ado, the Dutch court instead decided in favor of the claimants. Please, next. Okay, so without going too much into details, the important thing now is to acknowledge that this Urgenda case was considered the source of inspiration of many other cases in Europe. So the arguments used by the Urgenda foundations were adopted and transplanted into other legal systems, taking due care of adapting, of course, the way of construing the case to local legal circumstances. circumstances. So this was the case for the Klimaatsact in Belgium, where practically the same arguments were used in order to get a successful decision in Belgium. Please, next. Well, I don't. I will go forward because I think that the time is now running fast. But anyway, this was the case in Belgium where the association succeeded with similar arguments to the one in Urgenda case. Please, next. Please, okay. Then the same thing was used in Affaire du siècle in France, where it is important to note that very recently the French legislator introduced a specific norm in the civil code related to ecological damage. So it was even easier to have a point of reference in the Code Civil, in the civil code, to develop the whole case. So the same thing happened in France. Please, next. And the other thing that is interesting is that in another case, this time brought in Switzerland, the Urgenda case was always considered a source of inspiration, although in this case, the requests of the actresses were not based on the violation of the general principle not to harm anybody, but on the violation of fundamental rights. So this case, on my opinion, is very important because it gives you the idea how an important case like Urgenda becomes a source of inspiration, and the main ideas are transplanted and copied into other legal systems. Please, next. Okay, in this case of Switzerland, the particular issue was very interesting because in this case the actresses were older women who were stating that they were particularly vulnerable to climate change impacts. So for this reason, this association, Klimaseniorin Schweiz, Senior Women for Climate Protection Switzerland, I would translate, filed a legal request with the authorities, claiming that the Swiss authorities were failing to fulfill their duty to protect them as required by the Swiss Constitution and by the European Convention on Human Rights. Please, next. This case was not successful in Switzerland, so the many authorities involved denied the claim of the association, and that is why, please, next. Okay, this is why the association now brought the case in front of the Court of the Human Rights in Strasbourg, where it is still pending. Please, next. Okay, other cases that, on the contrary, were based on a common law background, that is to say, on a tort-based system, like Friends of the Irish Environment against the Government of Ireland. Even here, although the basis is quite different, we see that the Urgenda case has been quoted as a point of reference, as a source of inspiration. Here, the National Mitigation Plan had failed to specify the manner in which it was proposing to achieve the national transition objective as required by the Climate Act 2015, and that is why the Friends of the Irish Environment claimed against the Government of Ireland. Please, next. Another important case, which was also successful, was the one that was brought in front of the Constitutional Court of Germany in 2021, claiming that the Klimaschutzgesetz, that is to say, the climate change law that was published in 2013 and then amended in 2019, was not sufficient, and especially the state had not implemented sufficient regulations for the immediate reduction of greenhouse gases, which were, however, necessary to prevent the heating to 1.5 degree or at least well below 2 degrees Celsius. And here again, the Constitutional Court of Germany considered the claim successful and ordered the government to change the Climate Change Act of Germany. Please, next one. Now we come to the brand new issue that also Justice Brian Preston was mentioning, the fact that we move from these kind of cases in Europe where the topic is against the state because it has not fulfilled its duties, to cases where the defendant are private companies. Here again, we have this very important decision of 26 May 2021, Milieu Defense against Royal Dutch Shell, which is taking over the argument developed in the Urgenda case, but also gives effect to some international principles that put obligations on private companies, and so the Dutch court acknowledged that Shell had a duty of care to take action to reduce its greenhouse gas emissions. Please, next one. Okay. Now, beginning to reason about these cases from the European perspective and reasoning about legal transplants in the field of climate change litigation. So in some cases, like in the case of France, Belgium, and the Netherlands, it is easy to understand why the legal transplants were easy to achieve, because they have the same legal background in terms of tort law. They have the same root, that is to say, the French Civil Code. So it is easy to make the argument to reason in this way. Well, what works for one legal system, what has been successful in one legal system should work also in a very similar one. That is why the idea of transplanting a rational, an idea, a concept is very easy to make. Please, next. Okay, but as I would like to point out, legal transplants work also in very different directions that do not take into consideration the global south or the global north divide. For example, there are some transplants that cannot be explained simply because of the similarities that we have seen before. And so global south and global north divide may convey us a lot of information on different attitudes and perspectives, but it cannot always amount to a heuristic criterion in terms of the understanding of legal transplants. Please, next. So, I'll give you an example, a very concrete one. So the reason why we find the same concept of public trust applied to natural resources in a climate change litigation in the US, I am referring to a specific case that is Juliana against United States. And in a climate change litigation in Pakistan, I am referring to Legari against Federation of Pakistan, can be most profitably analyzed and studied, taking into consideration the same common law tradition, the common use of English language, and the dialogue existing between different supreme courts as far as global issues are concerned. Much more than referring to the global south and global north divide. Please, next. So coming to the conclusions, climate change litigation has a huge interest for comparative lawyers because understanding the underlying forces of legal transplants would be very, very profitable for our research. And I think also for the success of climate change policies all over the world. But this implies to understand the tensions existing between global law and local law, between law in the books and law in action, and between the simple implementation and an effective implementation of the rules that are copied or transplanted. Next, please. And I would like to end with a quotation of the Supreme Court of India, which dates back already 1981. This quotation is very important to me because I think it gives you exactly the idea of what I have in mind. The Supreme Court was stating at that time, if the mere enactment of laws relating to the protection of environment would suffice, then India would perhaps be the least polluted country in the world. But unfortunately, this is not so. Next, please. So I would like to thank you very much. Grazie and Dhanyavad.
Thank you so much, ma'am, for such an enriching session. Ma'am, we have a lot of questions coming in from the viewers and the participants.
Oh my God, okay, fine.
Since we are running out of time, with your permission, ma'am, I would want to ask 2 questions which seem pertinent to the topic at hand.
Yes, please.
Yeah. The richer industrialized countries of the North contribute more to climate change than the developing countries of the South. And in turn, those in the South are left to deal with the consequences. This global discussion on climate change has degenerated into a North-South confrontation for perhaps obvious reasons. So, ma'am, what are your views on this North-South climate divide?
Do I have 100 years to answer? Well, this is a question that cannot be answered in few seconds. I think it is perfectly right to point out the responsibilities of the global North. I perfectly agree with the fact that the global North has enormous responsibilities as far as climate change is concerned. But on the other side, nowadays, we are facing a problem that is immense, huge. And I think that the idea of common and share responsibility is the one that should be taken into consideration because we cannot close our eyes in front of the urgency of this particular moment. I think that given the responsibilities of the global North, which is very, it's difficult to generalize, but let us use this word, the global North should help in terms of financing, technologies, and so on, the global South in trying to overcome this very difficult period. But this is a very superficial answer. I am perfectly aware of that, but I would need hours to explain all my ideas.
Thank you. Ma'am, the last question. According to you, what are the 3 top leading causes for climate change in the global North?
Oh, top. Okay. So, well, I think that my own opinion is that there is one very important issue. That is to say, we have been accustomed to a very consumerist approach to life. So we spend energy, we buy textiles that we throw away in few minutes without using them. We buy food that we do not eat. So I think that the very crucial point is the mentality that we have been grown into in the last decades. After the Second World War, the idea was we have to have progress, we have to buy cars, we have to have very important meals, we have to be able to buy clothes without really being aware of what we were doing. So I think that the principal cause is a sort of mentality that especially Europeans and North Americans have acquired towards generally the standard of life that they have. And then of course there are industries that are not taking care of what they are emitting, the problem of energy that we do not have taken into considerations. So I think that the very first reason is this way of looking to life, generally speaking, this way of attitude, this attitude that I would name it consumerist attitude towards life, the way by which we generally live our lives without being aware of the environmental and climate change problems that are connected to our way of buying and wasting things in all kind of sectors. And then, of course, a huge problem are the industries that are connected with that, the fact that we are raising cattle in a very intensive way, and so on and so on. But these, I think, are all consequences of the first big issue, that is to say, our way of interpreting what is a good life, instead of asking ourselves what is really, really important.
Thank you so much, ma'am. It was really insightful.
Thank you to you.
Now I invite Dr. Ridita Parikh, Assistant Professor, Faculty of Law, GLS University, to offer the formal vote of thanks to our esteemed guest for the session.
Thank you, Forum ma'am. Thank you to Barbara Pozzo ma'am for her enlightening session on the topic Changing Dimensions of Climate Change in Global North. Ma'am's session on climate change litigation from a comparative law perspective was really very insightful for this particular conference, that is Climate Change, Governance and Law. Ma'am very correctly elucidated on the concept of legal transplants in comparative law in the light of environmental law jurisprudence. Ma'am's righteous point on the juxtaposition of global north and global south in light of environmental law litigation has been, I think, the most relevant topic for all our viewers. Apart from that, ma'am also correctly pointed out by saying that it is the citizens' duty to protect the environment. And it is not only present in the Dutch constitution, but I think it would be present all around the world. Like if we would want to protect our environment, it is each country who has to fight back in order to save the environment. And ma'am, really thank you so much for bringing in so many cases from around the world to us, so that we understand that not only we over here in India, but it is each one who is fighting for the cause of the environment. So ma'am, thank you once again. It was really an honor and privilege to listen to you. Thank you so much, ma'am.
Thank you to you.
Thank you, ma'am, for being with us, ma'am. We look forward to having you with us in the future events of Faculty of Law, GLS University. Thank you.
Thank you.